Half a day, buenas. The Committee on Health, Land, Justice, and Culture is now called to order. Today is Tuesday, October 18, 2022. The time is 8:02 a.m. So in compliance with the Open Government Law, notices for this public hearing were published in the Guam Daily Post and the Government of Guam Public Notice Portal on Tuesday, October 11, and Friday, October 14, 2022. This hearing is being live streamed on the Guam Legislature's YouTube channel, and notice was also sent to all senators and all main media broadcasting outlets via email on October 11 and Sunday, October 16, 2022. Individuals testifying shall first be recognized by the chair before speaking and begin by stating their name for record-keeping purposes. So we have two agenda items this morning. Those are both bills sponsored by Senator James Moylan. Bill number 271-36 COR is an act to add a new section 61.75 to Chapter 61, Title 9, Guam Code Annotated, relative to defining punishments for any minor convicted of a crime associated with riots, disorderly conduct, and related offenses. Bill number 272-36 COR is an act to amend Chapter 25, Title 9, Guam Code Annotated, relative to increasing the minimum sentence of first-degree criminal sexual conduct and establishing minimum sentences for second, third, and fourth-degree criminal sexual conduct. I'd like to thank, of course, the sponsor of the bill and my colleague, Senator James Moylan, for being here this morning. Thank you, Senator. So we will begin with an introduction of the first bill, Bill number 271-36, by the sponsor. So, Senator Moylan, you have the floor.
Thank you, Madam Speaker. Thank you to the panel. Bill 271-36 is this legislation merely imposes reasonable yet stringent penalties on any minor who is convicted of crimes involving riots, disorderly conduct, harassment, loitering, obstruction, or other crimes where there tends to be an occurrence from juveniles. The legislation establishes monetary fines for those minors convicted of a crime, so they can understand what responsibilities entail. The measure further provides the judge with the option of determining whether the parents or legal guardians will be jointly liable. Bill 271-36 also mandates community service as part of the punishment, while mandating restitution when needed. Once again, the judge is provided the option of determining parental or guardians' joint liability. So sadly, we are seeing more of these types of actions these days on a regular basis, especially with social media and chat groups escalating. I agree that many of us did something silly when we were younger, and most of us had consequences to deal with. This taught us a lesson, so we don't repeat the action. Bill 271-36 is about establishing responsibilities and respect and enhances parental involvement when it comes to cases where a child is acting irresponsibility. Madam Chair, I look forward to hearing any testimony today which would help improve this legislation. Thank you.
We will now accept testimony from those who are here to testify. So we have Mr. John Morrison, Attorney John Morrison, I think the Deputy Director of the Public Defender. That's correct?
That's
Mr.
correct,
Morrison?
Speaker.
Please proceed.
Speaker, Senator Moylan, I wanted to discuss this issue briefly, and I think it's somewhat complicated. I'm not opposed to the goals of this bill, but I think as it's styled, it may end up confusing things in court. I certainly am of a belief if a minor breaks into a high school and riots in there and causes damage to the bathroom, that they should have to pay for it, that there should be ways for them to get good with society. And I think those things in large part already exist. I think the truth is that most of these cases never make it to the public because adjudicating minors is something that happens in confidential proceedings. For the most part, unless a child commits a crime so egregious that they're going to be charged as an adult, they're going to be governed by 19 GCA Chapter 5, which is the Family Court Act. And in that, those proceedings take place in closed proceedings. And specifically, those adjudications are not considered crimes. Those are, in that statute, in that chapter, the real concern of the court is getting jurisdiction over the minor. Jurisdiction can be gleaned a number of different ways, including if something the minor did would be considered a crime if it had been committed by an adult. So it's really just about getting that court jurisdiction, and then the court is free to enter orders that are going to be fair and appropriate under the circumstances. A lot of these things that the senator, that the sponsor is attempting to do are already within the power of those courts and the family court to do. The courts can get quite creative, requiring that parents shadow their minor child to school, which probably comes at considerable discomfort to the child. There's often orders for restitution. Our Family Court Act does not contain the word restitution, which is an issue that came up a number of years ago. However, many of our judicial officers see fit to order restitution in those cases because there is, because I think ultimately they think it's fair to require that restitution be paid, even though the word does not appear in our statute. As far as restitution is concerned, I think that is almost always ordered in these types of cases under our current panel of judicial officers. So I take issue with the language of the bill where it discusses any minor who's convicted of a crime, because that would simply never happen unless the minor had committed an egregious offense, a first or second degree felony, or gets waived into adult court. So as it's written, my concern is that this law would not end up meaning what I think the sponsor intends for it to mean, that it says any minor convicted of a crime pursuant to these sections shall be subject to these laws. Well, the minor would never be convicted of a crime. All that would happen in court is that the minor goes in, either admits the petition, denies it, and is acquitted of it, or is found to have committed the conduct, and the court gets jurisdiction and feels free to order further. I do take some issue with the financial cost here, because in handling these cases over the years, I think it's unrealistic to think that the minor or their family would be in a financial position to pay some of these fines. I think that would take years, and the minor might age out of juvenile court prior to coming up with $1,000, $2,500, or $5,000. I think it may be a better idea if the legislature is truly concerned about restitution or making good, that all minors be assessed a surcharge or something like that, and it be put into a fund similar to the Criminal Injuries Compensation Fund, where over time the fund would become large enough to actually do some good. So in summary, what I would say is that if the legislature truly wanted to change the type of orders that the family court could make, I would consider adding an extra subparagraph to 19 GCA 5114, where the family court would specifically be authorized to order restitution. As I said, it's already done in many cases, but this would be some legal reassurance that doing so is appropriate and legal. And those conclude my comments on it, but I see that we're about to have another highly qualified, it's on the juvenile one. Thank you very much for the opportunity to comment.
Thank you very much, Director Morrison. So for the record, we also received, we invited the Office of the Attorney General to testify. We received a response that says, Hafaday Speaker Terlaje, we apologize we're not able to attend tomorrow's public hearing, but we will be submitting written testimony. Thank you. Have a great, blessed, and safe evening. Sinceramente, Gabriela P. Rojas, Ripple, Paralegal. We also invited testimony from the Judiciary of Guam, Probation Division, And we received a response from the Judiciary, Sofia Santos Diaz, Director of Policy, Planning, and Community Relations. And I'm just going to read excerpts. It says, neither Bill number 271 nor Bill number 272 appears to have any direct impact on the services provided by the Probation Services Division. Bill number 271, for example, while extending monetary liability to parents of minors for restitution, does not give that division any authority over monitoring the collection of the same as it relates to the parents. It also says the judiciary is also always concerned when laws impose minimum sentences for those found guilty of criminal offense because such minimums limit the discretion of the sentencing judicial officer who is in the best position to assess the financial circumstances surrounding crime. While we offer no opinion regarding support or opposition to these bills, please note our concern regarding how the prosecution or the prescription of sentencing mandates impacts the discretionary authority of the sentencing judicial officer. And then there's another paragraph regarding the potential fiscal impact, which they said it's primarily related to Bill 272, so I'll read that when we get there. We also invited the Guam Bar Association, the Department of Youth Affairs, the Guam Behavioral Health and Wellness, the Anafa Maulik Conciliation Guam, the Guam Department of Education Student Support Services, the Mayor's Council of Guam, Manetlu Guam, Guam Positive Parents Together, Inc., Sanctuary, Inc., National Association of Social Workers, and of course the public. But I see we also have testified on this bill, Attorney Kathleen Uggan. Attorney Uggan, please proceed. If you could state your name for the record.
My name is Kathleen Uggan. I am an assistant public defender going on 4 years, primarily in the Juvenile and Family Court Division. Prior to that, I have over 15 years of teaching experience, primarily in elementary. And so I have a lot of experience in the cases that this bill concerns, in that our clients in juvenile court are charged. I've seen these all come up. And the problem that I have with this particular bill that I do not support at this time is that it calls out one specific set of laws. And all the laws are applicable already through the Family Court Act. All the laws of Guam are applicable to our juveniles. And I believe that the Attorney General's office is doing their part in charging those out, because I believe in just this last week, I pulled just a random case that we received that we were pointed to, and we're at JD roughly around 111 cases. And that's not to say that Public Defender has all of those clients, but that's where we're at as far as just this year, how many cases have been charged on the juvenile delinquency portion of the AG's work out of their family division. And so with that, I can't tell you that the laws that are here, you know, for this bill consisting of rioting or disorderly conduct, that's primarily the most of those, you know, types of criminal behavior that I'm seeing. It's not to say that it's a majority. It's all the laws come in and they're charged out accordingly. And I believe that through the Family Court Act, that the work is being done, and you know, as it is, and that the flaws, particularly in this bill, is that one, first, that this is only covering a set of laws, maybe, you know, 6, I believe I've counted 6 to 8. And so the punishment or the imposing of more sanctions would then be an imbalance, because all of those other clients that I serve, excuse me, would not have to be required to do the, excuse me, with all the other impositions of the sentencing and going through the cases, it would create a big imbalance among just juvenile offenders, because some would be required to do it based on just this adoption, and the others that I can think of just off the top of my head that my juveniles, have been punished for, criminal mischief, criminal trespass, there's burglary to a motor vehicle, aggravated assault, and those are not in the bill, nor do I want you to expand the scope of this bill, because aside from, just that it takes on more stiffer punishments and now includes the parents, it already creates a disproportion there too, because when I looked up these particular crimes, for example, just starting with rioting, at first rioting is charged as a misdemeanor, and misdemeanors do not have fines of $1,000 or up to $1,000. John's more knowledgeable on knowing how much a fine would be up for a misdemeanor. 500? Not 1,000, right? Because those are felonies. When we talk $1,000 and $2,000 fines, I'm thinking felony-related crimes, and those fines. In our case, I've worked on, with my clients having their parents file financial declarations because they just don't have the means to pay, even $50 sometimes, and they're, some of our clients are indigent, so they're very reliant on public services, so if we were to sit down, and I appreciate, I missed who had provided the testimony, but as you were reading, all of the service providers that were mentioned were brought up in our case too in discussing this bill, because having them at this table, so many other options are available. I think we're just, they're just not out and lined, in the statutes. But using the Family Court Act again, there is a reference already in section 5127, and it's the Juvenile Conference Committee. And it explains that the presiding judge would appoint people, and so in looking through this section on the Juvenile Conference Committee, it explains that this Juvenile Conference Committee would be appointed, and probably including some of those service providers and possibly, juvenile attorneys, that would determine the factors brought up about the antisocial behavior complained of, and shall devise ways and means of setting up an individualized service plan to aid the juvenile so that he or she may be developed into an acceptable member of society and a good citizen, so as not to become a confirmed delinquent or criminal. And what it says is that this committee would be used as determining the outcomes or the disposition, as it's called, by the court with the juvenile offenders. And so I also pulled one of my offer letters, as they call it, from the Attorney General's office, somewhat mirrors a plea agreement in a criminal case. So these offer letters are intended to have the juvenile offender agree to the terms and not take the case through a fact finding, which would be like a trial. So the juvenile would know what to expect if they were to admit to their crime, right, at the beginning of the case. And examples, pretty standard by the Attorney General's office, is that there would be a remand to DYA, there would be time for credit served, that they would be on house arrest, probation. There is a component already for service learning hours, and I've seen it be at that 180 hours. So that's already going on, and I saw that in the bill. There are laws, the court imposes orders to the juveniles to obey their parents' Guam laws, school rules, and court orders. They're ordered to attend school daily with no unexcused absence. I've seen the court order C's and above, and And then they go through a process which it would be great if the juvenile probation office was included too in providing testimony, because they have a evidence-based risk assessment that they conduct. And the court uses that as well as a tool to determine what the outcomes are. And the disposition goes through. Oftentimes, there's a component to have an assessment at client services. And that client services assessment also gives input into what the court, would order for our juveniles. And with that, I think that the laws in place or the outcomes that I believe this bill is looking to seek are already in the books and in the system. I think for me, what I think would be better suited at this time, if there's like a deep concern, which I understand, Senator, why you would think to put this into law, that roundtables occur so that we know what the service providers can really provide, and if they're doing it, and if they're being supported. But in my case, what I see is that everybody is doing their job, and that my juvenile offenders are not so much repeat offenders as well, when they complete the treatment and the provisions that are required by them. And I can say that I can provide numbers and stats, just not at this time. But if I'm, given the 10 days for written testimony, our office does, plan to be able to show more data, because we have it. I have seen the impacts, and that's for what I think about just Section B on going down, right? So for Section B, Section 1, this is another section that I oppose, in that I believe that there may end up being nothing, because for example, our clients in paying back restitution already are unable to do that, and there's a law in the books on restitution that they have a fair opportunity, that they have the means to pay the restitution. And oftentimes the court sides with our motion to limit restitution or to eliminate the restitution component in the case for the juvenile, because they just don't have the means to pay even the a portion of the damages. And in looking at the amounts of the fines that would be imposed and applying it to the actual crimes that are here in this bill, just going down the line, I believe, like example, I used riot. The fine may not be up to $1,000. Petty misdemeanors, I think, is the one I'm thinking that the cap is at $500. And none of these here are felonies. And I feel that the imposing of these fines is inequitable to put on to our clients who are indigent already. And then because there would be no property, or just going through the process, you'd find out that you'd not get anything. So I don't know if that's the deterrence here. So I wanted to bring that up. And then going to the schools, I believe that the schools already have their discipline outcomes, and I've seen it many times, because I wonder myself, how come we're going through this case when, for example, a kid right now, he's out for 10 days from school, like he's sanctioned, and in that sanction, they do have work detail, they do have a suspension, they have in-school suspension, and if these kids are already in the system and they're our clients, they are usually detailed to the DYA outreach locations. They're called maybe learning centers, like, I don't know their term, but they have service during the day for those students. It all applies differently, but it exists. And so I think that we'd open up a new, almost like opening up Pandora's box in the section of the bill in which may require parents to supervise at the school. I wouldn't want for now adults who don't belong there in the school to be on the school premises because they're supervising their kids, and then something worse comes from it, because we don't always know the state of the mind of the parents. We don't know, their intentions, and I don't think the schools are equipped at this time to just take that role on of allowing, parents to come and supervise, and just having them be on the school property is a concern as drafted here. And I think if you'd like, I can answer questions, but I think I've spoken on my concerns as written, and I do make myself available to, sit and come up with better consequences, or better, more like positive changes, because I believe that's the intention of your bill. So I'd like to volunteer myself to be part of, coming up with alternate solutions as I think the bill intends. Thank you.
Thank you, Ms. Ogun. If I could state for the record, you or confirm that you are currently an attorney at the Guam Public Defender Service Corporation,
Yes.
right? And a former teacher for many years.
Yes.
All right. And thank you both for your testimony. I want to acknowledge the presence of my other colleague, Senator Terlaje. Thank you, Senator, for being present. And so I guess I'll begin with the bill's sponsor, if there's any questions or comments for the panel. Oh, he'll wait for the closing. All right, so Senator Taichigui?
Thank you, Madam Speaker. Good morning. I was running a little late. I apologize for that, but I was listening on the YouTube. And thank you for the comments, because I too had concerns about this legislation, the way it's written. You mentioned, Attorney Morrison, that there are things in the court right now that they address circumstances like this that come in front of the judges. And, I too thought that's usually the case. But you mentioned that sometimes the remedies or the orders from the judges are never put in the public because they're minors. So are these closed cases in the court when a minor comes in front of the judge with their parents, and then the judge gives them an order, whether they do community service or anything like, is that closed to the public?
They're confidential proceedings, so the public is not invited into them. The idea there is that this is a juvenile, and our motivation, the motivation of the court and the parties is different than it would be in a criminal case. The motivation is really to restore the child, to take the child into their interests into consideration, and part of that is keeping them outside of the media, outside of the public's eye there, except for the most extraordinary cases that could be waived into adult court or generate an adult court if they're serious enough. So yes, these types of cases, things like riot, disorderly conduct, the public's never going to know what the orders of the court were to try to remedy the situation, fix the child, help the child become more law-abiding, or whatever the case may be.
Is there any data? I mean, I understand that we have to keep their names, confidential, the hearings, but is there any data that the court puts out on how many minors were sentenced to community service for X amount of time, the aggressiveness of the crime that was committed, and then what was the remedy, or things like that? Is there any data?
Senator, unfortunately, I'd have to ask the court on that. Certainly, Attorney Uggan here would have a sense of what's required in each case because she appears in many of our cases. And I can tell you from when I used to do this type of work, I had expectations of what the final result was going to be. If there was a finding that the minor had committed what would have been a crime if they were an adult. And under almost all circumstances, I would expect to see the things that Attorney Uggan spoke about. Community service, I think, in all cases, or service learning. And most courts were willing and are willing to order restitution. I've even seen judges impose restitution ultimately against parents for days that the minor spent in DYA, that's not free for the government and that they should be made to pay for that. So that's not something you would find in our Family Court Act, but it is something that judges have felt free to order in the past and maybe to this day continue to do that.
Okay, I'd like very much to get that kind of data for us. I mean, we trust our judges that they're making the right decisions. I mean, they measure the situation out, determine what the family can and cannot do, you know, after reading the background of individuals, which is very important. But and we have to provide that, you know, or not provide, but have that trust in our court system. But it's good to know that there's data available for us to see. And any time that we interject as lawmakers, you know, to just strengthen, you know, certain areas, or we're finding out that these penalties that are given to minors are not doing anything. It's still causing these individuals to go out there and think they can get away with just a slap on their hand. So I think it'd be important to get that kind of data. Kathleen, Attorney Kathleen, thank you so much for being here as well. You know, I was always wondering when I was looking at this, are there any counseling or other services offered or even mandated by the courts for these families or these individuals, these minors creating these crimes?
Yes, I was about to say, Your Honor. Yes, Senator.
Go ahead and pull the mic. Can you pull the mic
up?
up closer? Just
Yes.
Yeah, it'll be very.
There are. That exists and it occurs. And so I know that the Client Services and Family Counseling Division of the court is very busy because both juvenile offenders and adult offenders are often recommended, and that's based on an assessment done by probation that recommends to go through the counseling route. So what the court adopted through the juvenile, or through probation, I know it's a risk assessment, and based on that, at the beginning of the case, the recommendations are made, and the court usually adopts them in the sense that the client has to go to Client Services, get the assessment, and follow all treatment recommendations before the case can close, right? And aside from that component, there's also Guam Behavioral Health and Wellness Center that provides ifamaganta counseling services for a certain age group. And then I've seen even further orders from the court in psychological evaluations, off from this, but even when it comes to sexual crimes, there is a component that the court orders for psychosexual evaluation be done by Client Services. There's also even further at Guam Behavioral waiting list for psychiatric evaluations, and those all come in, and the service providers from there come into the case and develop the action plan for that juvenile. So it's not a standard, each time the disposition, it's really based on the recommendations by the service providers that have been ordered to, for the clients to complete. And that's why I think in going back to the Family Court Act and looking at Section 5127, where this Juvenile Conference Committee is detailed here, I think perhaps before moving into making, stiffer penalties or moving in the direction of this bill, coming back to that committee and asking the court, what are we doing there? Because it tells that there is data to support, or, that was the expectation in my understanding of the conference committee, from the court, because they would be looking at the data and where, you know, is it lacking or is it strengthened? Because even at DYA, when our clients are confined between the pickup, like the incident, and the, you know, so-called arrest, and then taken to DYA, there's usually a procedure that occurs while on its way to the judge, is that there's a risk assessment there too. And that also, so there's, I know he's Mr. Ed Taitano at DYA. He provides the, conducts the risk assessment with the juveniles and provides that to the court. So even just at the onset, the court has that information on where the risks are, whether it's substance abuse, whether it's trauma, whether it's defiant behavior, anger, you know, all of it is there because there's a screening and that risk assessment, and that's used by both the judge, the council, you know, government. Everybody uses that towards making the recommendations, and then the court adopts that. And also at DYA, there's many social workers. So each client there is assigned a social worker, and they also they work in like cohesively with juvenile probation and counsel, and oftentimes, and that's why it's fitting. I wanted to talk about just, you know, we didn't plan it this way, but our juvenile division at this time right now consists of a former probation officer with the court, me with a former background in teaching, and we have William Jones, who's has a background in mental health. And, you know, he was at mental health before coming into the law. And so for us, we see and work with our service providers for our clients to, you know, exactly as the bill intended, to have more positive outcomes, and the court, like Mr. Morrison said, looks at restoring the child or the juvenile. And I always tell them that you're going to learn skills of preventing the same type of behavior. So all of that is embedded already in their cases.
Thank you, Attorney. Again, I think, Madam Chair, we just had an oversight hearing of our juvenile system, and it was very thorough. I really appreciate all the work that you're doing. Sometimes the public doesn't hear this information, you know, but I appreciate all the work that you're doing. And the data that you mentioned several times in your comments, because that's going to be very helpful. Next time anybody wants to write any legislation, you know, do the homework, you know, to assess this thoroughly. But I really appreciate the work that you're doing, Attorney, again. And thank you, Attorney Morrison, for always being here. I really appreciate your presence. Thank you. Thank you, Madam Chair.
Thank you. So I have a couple questions. First of all, I'd like to state for the record that we received a fiscal impact note from BBMR that says that the bill's administrative in nature poses no fiscal impacts on the government of Guam funds. So the bill's intended not just to impose, well, it does several things. It imposes mandatory fines, mandatory restitution, and then mandatory community service. But in addition to all of those, it makes this joint liability with the parents. So I wanted to ask you about that part. So you're saying right now the courts have the ability to impose any of those things. What have you seen? Well, I guess the premise is that having the parents liable is going to deter the children from this type of behavior. And so I wanted to ask, the bill's intent says, research shows that, quote, additional domestic involvement can help deter future criminal activity by minors. So I wanted to know if you're aware of that. Does your research show or correlate that mandatory fines against parents increases or helps to deter criminal activity by the minors?
I don't have any information supporting that or, you know, against that. I just haven't looked into that, but I can.
Attorney Morrison?
Madam Speaker, I don't have that information. I'd be surprised if that bore true under the unique circumstances that occur in family court Frequently, the financial situation of the parents is particularly dire. We go into court. Frequently, both parents are there for their preliminary hearing. They sit there for many hours, and obviously the gender of the parents is irrelevant here. It could be mom working, it could be dad working, but frequently, just by way of example, dad's missed half a day of work because he sat there in court, and maybe he doesn't show up to the next hearing, which would be an answering for the child. Mom's been there all day as well with the potential delinquent as well as some of her other children. That's frequently the case. And if dad doesn't show up at the answering, sometimes the judge will order that he does show up. So dad shows up again, misses another day of work. Unfortunately, missing the margins here for these families is razor thin, and missing those days of work has a real impact on them. So I'd be surprised if there's going to be the ability over the course of this case, which we want to be relatively quick, for these parties to be able to pay $1,000 to $2,500, $5,000, whatever it is, because the margins are already so tight. I wouldn't be surprised if this created more of a wedge between the delinquent and his family, where over the course of time they're looking at him or her more like they're a detriment to the family and don't necessarily want to have that person under their roof anymore because of the potential financial cost. I'd be surprised if there was going to be a real value in bringing the family together or making them appreciate and take things more seriously. We have a robust and thorough system. The parents and the parties are already taking things seriously. Many of these orders are already into place. And I think there's a risk here that it would drive a financial wedge in between the child and their family.
Thank you. My staff was able to pull up two studies. So one was according to the Juvenile Justice Center, which shows that the justice system imposed financial penalties increase the likelihood of recidivism in adolescent offenders. Young people with justice-related debts are more likely to reoffend than their debt-free peers, and the likelihood of reoffending increases as the fines and fees rise. This makes communities less safe. The center further stated that, like cash bail and other criminal court charges imposed on adults, juvenile fines and fees recreate racial and economic inequities. They unfairly push youth of color and youth in poverty deeper into the juvenile justice system. Youth who can't afford to pay these costs are more likely to be incarcerated, face prolonged prison time, and remain on probation longer, while youth with financial resources are more likely to stay at home and access effective community-based services and treatment. Youth shouldn't be punished for poverty. Income-based justice isn't justice at all. That's a quote from the Juvenile Justice Center research. There was also a 2020 study published in the Children's and Youth Service Review Journal, which examined perceptions of and preferences for parental responsibility amongst 662 respondents and found that a great majority of respondents perceived that providing training was markedly more important than punishing parents for their child's actions. Participants in our study placed substantial responsibility on parents for dealing with juvenile offenders. However, support for punishing the parents was low, while the importance attached to enrolling parents in training was high. Views on parental responsibility were influenced by the age of the juvenile and the seriousness of offense, of course. So, do you think if we took this language, so one of the suggestions was we could take some of this language and put it as so it's in writing in the Juvenile Justice Act, that these are options for the court. Right now they're using these options, but we could put it in that these are options. Do you think that as it's written, it would limit the court? It would be what the court describes as that mandatory minimums, or taking away their discretion in the cases, and should we steer away from that?
Madam Speaker, it depends on how it's phrased. I think Obviously, the court is in the best position to know the background of the family, their financial situation, the needs of the child, if there's mental health concerns here, how the child can be assisted, what's going to be best for them, how much longer they have in school, are they going to graduate? Those are all things that the court needs to take into consideration and can and does in virtually every case that I've been associated with. So I would say if the language in there was discretionary, gave the court the authority in writing to order restitution or to impose certain penalties, then as long as it's discretionary, I don't think that there would be as much of an issue. Of course, I wouldn't pretend to speak for the judiciary on how they're concerned about limiting the authority of their judicial officers, but I think logically that would make sense that if this were discretionary and the court could impose it, there's probably a bit less of a concern logically. I think the concern here is that if it's mandated in every single case, and we're going to assume in every single case this is going to produce the best outcome, and we're probably mistaken.
Right, I guess that's my question, right? If it's mandated versus allowing the court's discretion. So, so a judge, a social worker, counselor, or principal's recommendation to the court for parent training versus the application of fines,
Yes.
if taken as written, would not be possible. I mean, well, they'd have to do the fines as well, and all the others. And then these do not, as written, does not take into consideration the ages of the offenders, I guess, those violators. And so that's another thing. So the court does not have discretion based on age or other circumstances, it looks to me. But I think that your testimony's pretty much covered all the rest of my questions, so I want to thank you for that. I'll now allow the sponsor, Senator Moylan, to close on the bill.
Thank you, Madam Chair. Thank you, panels, for good information and sharing that. I was working in that system previously at Department of Corrections as a parole officer, so your explanation I understand. And I want to thank you for looking at ways to improve the legislation. That's very helpful, and for sure we'll be contacting and like to talk to you more about that. But that's what these public hearings are about. Looking how legislation can help, looking how legislation needs to be adjusted, and just looking at the betterment of the island as a whole, protecting our community, and also rehabilitating the person involved. After all, we're just a small island, and eventually everybody's majority are released, and hopefully don't go from juvenile to adult situations. So, Madam Chair, I thank the panel as well, and I appreciate the opportunity to present this bill before the public. Thank you, Madam Chair.
Thank you very much, Senator Moylan. So there being no additional individuals to present testimony on Bill 271-36 COR, the committee will consider that bill duly heard, and we will move on to the next agenda item. So the second agenda item, Bill number 272-36. So I'll allow the sponsor, Senator James Moylan, to introduce the bill.
Thank you, Madam Chair. Bill 272-36 is about enhancing the right of the victims of the criminal justice system. Victims of criminal sexual conduct crimes by increasing penalties for those individuals convicted of criminal sexual conduct. Almost daily, we are seeing stories in the news regarding the rise in criminal sexual conduct cases. And one too many times we see sentences which sadly don't suit the crime. And even more unfortunately, does not bring a sense of justice for the victim. This legislation increases the penalties for those convicted of first to fourth degree CSC, inclusive of those who plead down to third or fourth degree. For example, for the first and second degrees, the minimum sentencing would be set at 25 years instead of 15. However, of course, I would like to listen to the comments of the panel and improve the legislation by moving forward. So I thank you for this opportunity, Madam Chair, to present Bill 272-36. Thank you.
Thank you very much, Senator Moylan. So again, we did invite the Office of the Attorney General, who responded that they apologize not able to attend tomorrow's public hearing, but we will be submitting written testimony. That's from the paralegal at the AG's office. We invited the judiciary, who did submit testimony. We invited the Public Defender Service Corporation, who is here with us today, thank you, and we invited the Guam Bar Association. So we will now accept testimony from the, well, let me just read real quick, the judiciary's testimony. I'm reading the excerpts relative to Bill 272. It says, Bill number 272 appears to remove probation from any responsibilities as they relate to criminal sexual conduct offenders, since probation would no longer be an option at sentencing at all. The judiciary is always concerned when laws impose minimum sentences for those found guilty of criminal offense because such minimums limit the discretion of the sentencing judicial officer, who is in the best position to assess the factual circumstances surrounding crime. While we offer no opinion regarding support or opposition to these bills, please note our concern regarding how the prescription of sentencing mandates impacts the discretionary authority of the sentencing judicial officer. And then as to fiscal impacts, they say Bill 272 may result in a significant fiscal impact to the judiciary. Constitutionally, every indigent defendant is entitled to a lawyer appointed by a judge and paid for by the judiciary under the Supreme Court of Guam Indigent Defense Rule. The rule sets caps for a court-appointed attorney's fees in criminal sexual conduct cases. The amendments in Bill 272 would result in an increase to the applicable court-appointed caps in second, third, and fourth degree criminal sexual conduct cases. All of this testimony has been provided to all the senators. So we'll now accept the testimony from, again, Deputy Director Attorney Morrison from the Public Defender Service Corporation.
Thank you, Madam Speaker. I'm here to speak in opposition to the bill. I would say first, just by way of background, in July of this year, I was here before many of you, and we had a roundtable discussion that was quite lengthy and involved a lot of participants, and there was quite a bit of information that was exchanged between the true stakeholders and the legislature based on the difficulties in investigating these types of cases, the difficulties in prosecuting these types of cases, getting treatment to the people that are justice involved. And specifically, the Attorney General, their chief prosecutor, indicated that they were okay with a mandatory minimum on first degree CSC, that crime rises to a level that a mandatory minimum may be appropriate. But for all others, they asked the legislature to give them discretion to look at these cases and try to bring about a just result. So I was hopeful that the next round of legislation proposed would jump on what somebody said during that roundtable and try to fix one of the problems that had been presented. Some of the problems of how not to traumatize a victim when the case is being investigated, how to limit the number of interviews that are conducted, how to interview that person using a highly qualified expert who's going to not traumatize the victim and is also not going to inadvertently implant memories in that person or do something that screws the case up. How maybe we can financially support a victim as their family goes through this, particularly in cases where the breadwinner is the one for the family is the one that's being investigated or is incarcerated for the crime. But I don't see that this legislation does any of those things. It seems to be somewhat of a cookie-cutter approach that all these crimes rise to a certain level, whether or not it's first, second, or third degree CSC, where 25 years is the appropriate sentence. And I don't believe that is the case, or that there's really any data that would suggest that it is. I understand the motivation of thinking that these crimes all rise to a level where people need to face a serious sentence, but I think this is misguided in that respect as far as the types of outcomes that we could expect. I wouldn't expect that this is going to change what the true outcomes are, because if the police and the Attorney General are saying My issue with the case was that the minor victim either recanted because what they said wasn't true, or recanted because they realized that my uncle's going to go to prison for 25 years, and that's really not what my intention here was, that this is not truly going to fix any of that. However, I think there probably are ways that the legislature can assist in some of those problems, particularly in funding for qualified experts who are going to interview child victims. DOC and parole sat to my left during that roundtable, and they both indicated that currently there is a problem with getting sex offender treatment while they're in custody, and they suggested that it should really be Guam Behavioral doing these types of evaluations and treatments, and there's not currently a way to get somebody transported from DOC to Guam Behavioral to attend their treatment, and there's obviously a lack of qualified treatment providers. So those are in general my opposition to it, is that it looked like none of the stakeholders actually asked for it, and some of the people most involved with it specifically warned against it. I would say, as far as the actual language of the bill, I would start from the beginning. There's a number of portions in here that suggest that it can be a misdemeanor, that the statute's aim here is specifically with those criminals preying on minors. Then it goes on to discuss a first-time offender being charged with a misdemeanor under 4th degree. And that may be possible under the 4th degree statute, but the legislature modified the 4th degree statute during this very legislature. So it's now been modified that if it was a minor involved, that it's going to be charged out as a felony. So the intention here, if it's truly to protect minors, seems to be already in place. I can't say that I agree with the cookie cutter approach of saying first, second, and third degree should all be treated as 25-year sentences, because they're factually different, and I think logically the law has laid out ways where we can say first degree is the worst type of conduct that deserves a different sentence than second degree. And second degree is more serious, the conduct is worse, it deserves a more serious sentence than third degree. But this seems to strike all of that. So currently, first degree might involve particularly violent conduct, a violent rape, where someone is seriously injured. We rarely get those types of cases on Guam, but we wouldn't have to look too far in the media nationally to see a case where somebody was brutally attacked and was left with serious injuries. Obviously, that sort of case is much more serious than some of the second or third degree types of cases that might involve touching or force or coercion, but not an actual violent attack. So I think previously there had been some logic to it, and this strikes a lot of that logic, frankly. I think Guam has some of the strictest CSC sentences in the nation currently. The real issue, I think, came from that roundtable discussion that some of the stakeholders' problems are systemic, and this doesn't solve any of them, and that there's problems investigating these types of cases, having qualified people to investigate them and interview child witnesses, and then problems once the offender is in custody, offering them appropriate treatment quickly, getting them that, and sustaining it. I think the judiciary was correct when they spoke about limiting judicial officers' authority, and I think that's right, that I think we still need the judicial officers to look at a case individually and say that this is different than the one that came before me from last week, and that's why I need to impose a different sentence, that this person has a mental impairment that's well documented, and I need to treat them differently than someone who's just vile. This person committed an offense, it looks like 10 years ago, and since then has been living a productive life. I need to treat them differently than someone in a different situation. Thank you very much for the opportunity.
Thank you very much, Attorney Morrison. I will now hear from Senator Taitigui. Any questions or comments?
Again, Attorney Morrison, thank you so much for always being here and providing us testimony, your input, and we definitely rely on your expertise to give us guidance. I too don't support this legislation as all. I don't even think there's a fourth degree sexual felony, fourth degree. So I concur with your findings, and it tells me that I was right in my thinking on this legislation. But I do appreciate you bringing up the roundtable that was brought up and some of the other concerns that were brought up, and I appreciate your input. We will put those concerns, I'll hopefully work with the chairperson to implement some of those findings that you thought we could move forward in strengthening our laws on Guam, but definitely I don't support this legislation, and I thank you so much.
Thank you, Senator. So we did receive a note from BBMR saying that this is just administrative in nature, would not fiscally impact appropriations for FY 2022. But so my questions on the bill, and I want to thank you for your testimony today, because that's pretty much what I was going to state as well, is that we did have a roundtable discussion with all the stakeholders, except for Guam Behavioral Health. They were not there at that roundtable, I think. And, but what we found, yes, was what you stated, that the issues that the police department and the Attorney General's office were highlighting were that the majority of criminal sexual conduct cases with minor victims were delayed. They had delayed reporting, that the perpetrators were friends of the family or family members, and that in these cases, the victims are not always willing to come forward, and they are reluctant to testify and retell their stories. And in these cases, the ability for a prosecutor to negotiate a plea deal can mean the difference between a perpetrator being set free or convicted of the crime by that plea deal and imprisoned. And therefore, there is a need for a judge to be able to apply discretion with the sentencing. At that roundtable, we had requested data on the number of plea deals versus cases taken to trial, data on if we are seeing a prevalence of recidivism of sexual offenders on Guam, and the recidivism rates of adult and young sex offenders, and we are still pending receipt of that data. This was a roundtable held in July of this year. During the roundtable hearing, we also inquired on the status update of the types of risk assessments that are being conducted before and after release on probation, pre-sentence, or parole, and the availability and effectiveness of treatment from the judiciary, the Department of Corrections, the Guam Behavioral Health and Wellness. And we learned that despite the prior law that we had passed, Public Law 35-71, which mandated that a standardized risk assessment and system of treatment for criminal sexual conduct offenders in particular be implemented, that had not been implemented by either of those any of those entities. So there was no risk assessment specific to criminal sexual conduct reoffense, and obviously, as you testified, not enough treatment providers on Guam for this. And that was part of the reason that bill was passed. If there are no treatment providers, we have to deal differently than as opposed to acting under the assumption that they are being treated and things will be different when they are released. In previous testimony, Dr. Patricia Timinglow from the Department of Corrections had testified that physiological testing plays an essential role in assessment of sex offenders, and outlined that a comprehensive psychiatric eval would include reviewing available police reports, criminal history, collecting available collateral sources of info to verify information provided by the individual, detailed sexual history, history of violence as a youth and adult, and careful evaluation of deviant sexual arousal patterns. She stated that it's essential that the assessment be completed at the pre-sentencing level. Then you had also testified, the public defender had also testified in a previous hearing in the last legislative term for bill number 96-35, and you gave very detailed testimony against that bill, highlighting some of what you've said this morning, that there were no relevant evidence-based studies which demonstrate the need for a mandatory minimum, and that, or in particular, the 25 years. And they had testified then that a mandatory minimum sentence is not necessary to protect the public because generally the judges will impose a long sentence already permitted under the law. And as you said, we have some of the strictest laws. There are many reasons a case charged at first degree gets reduced with a plea agreement to a far less offense, and one of the reasons is because the mandatory minimums. Often a victim wants to avoid the trauma of confronting their perpetrator in court, in front of a judge and jury, and now the media. And with these mandatory minimums, I think the comment was made that kind of forces these defendants into trials as opposed to trying any other resolution. According to the U.S. Department of Justice's National Institute of Justice, quote, laws and policies designed to deter crime by focusing mainly on increasing the severity of punishment are ineffective, partly because criminals know little about the sanctions for specific crimes. More severe punishments do not chasten individuals convicted of crimes, and prisons may exacerbate recidivism, unquote. Furthermore, increasing the severity of the punishment does little to deter the crime, according to the U.S. Department of Justice. So those were what I found based on the previous bill that had a hearing, based on your previous testimony, based on that roundtable hearing, which I agree gave us some very good parameters to address our concerns and the community's concerns regarding repeat sexual conduct offenders, criminal sexual conduct offenses in general, or in particular. And so I want to thank you again for your testimony and for your testimony on all of these occasions. Very, very helpful for us.
Thank you, Senator. It's my pleasure.
So I'd like now to invite Senator Moylan to provide closing remarks on the bill.
Thank you, Madam Chair. Thank you, Attorney Morrison, for your testimony on this bill, which was introduced earlier this year as well. But very good input that you have. Of course, this is what the public hearing is for, to strengthen the measure as well. And also understanding the protection of the victim and the situations that come about, but we're also looking at protecting the future victims, and hopefully that doesn't happen too. So I appreciate your time, especially on both bills there. So thank you for your time and your input and what you do for the island of Guam. Thank you so much. Thank you, Madam Chair.
Thank you very much, Senator Moylan. And again, thank you to Attorney Morrison. There being no additional individuals to present further testimony, this committee will consider Bill number 272-36 COR duly heard. The committee will remain open for the submission of additional written testimony for the next 10 working days following this hearing. That will be November 1st, 2022 as a deadline, on both bills 271 and 272-36 COR. Please send testimony via email to Senator Terlaje Guam at gmail.com or hand deliver to my office here at the Guam Congress Building. So public hearing is now adjourned and the time is 9:10 a.m. Si Dios masi.